Hello, my name is Jingo Nelly, and today we are going to be looking at another tutorial. But before I begin off, make sure you subscribe to the channel. It will bring you some good luck in your forthcoming exams. So in below we had ended at voting at meetings. So here they're saying unless the articles of the company provide otherwise, each member has one vote, and voting is done by show of hands, irrespective of the number of shares held by each. And voting can either be by poll or by proxy. So with this under section 144, it says that poll may be demanded before or by the show of hands, where the articles provide that voting shall be by poll in a company with a share capital. Each member has one vote in respect of his shares. So this means that a shareholder with a higher number of shares has a higher vote. So here it's going against the first statement we had at first, whereby it was saying each member has one vote, and voting is by show of hands irrespective of the number of shares held by each. So here the articles are they're being looked at otherwise. Yeah. So this is that's why they're saying where the articles provide that voting shall be by poll in a company with the share capital. So meaning that in the company with the share capital, the shareholder with the highest shares will have a higher vote. So meaning that if at all we are having a meeting, such people with higher shares should be given a chance to direct the company. So moving on, looking at the something to note with the articles of association, then with this, and they're saying with the articles of association, the articles of association cannot exclude the right to demand a poll or require a specific percentage of members with a specific number of shares to demand for it. So here, it is not in law for the articles to stop somebody to demand a poll or require a specific percentage of members with a specific number of shares to demand for it. So still under section 144, it is stated that either 5 members are entitled to vote, or shareholders with at least 10% of the voting rights can demand a vote by poll. So the rationale here, or the rationale behind this, is that voting by poll is a presumption that those who are likely to demand the poll are the members with the highest stake in the company. So that's why I told you earlier on that these people should be given at least a chance to direct the company, because they will be having that overall power to rule out their other fellows with lesser shares. So accordingly, if an important matter relating to the company's policy is before the meeting, so if I told her to decide on some particular important issues, so that's when such people, the ones with the higher shares, they have to be given a chance in order to direct this. So looking at for a situation whereby in case of any provision in the articles of association which tends to exclude the right to demand a poll is invalid. So the articles of association does not restrict one to demand a poll. So here we look at a case of Reclaimants versus Reclaimants Limited, whereby it was saying an auntie who framed resolutions attempted to get the plaintiff out of any control of the company, and the company set the resolutions aside on the ground that it wasn't done in good faith. So this auntie wanted to put out the plaintiff out of the company by just framing him to some particular resolutions which weren't in good faith. So the court denied that. So that's when the court can deny. That's when a situation can come whereby they deny somebody to demand a poll when it's not being done in good faith. So you just look at that case of Reclaimants versus Claimants Limited. So moving on to proxy. looking at proxy. A proxy in company law is a document which authorizes somebody to attend a meeting on behalf of a shareholder. So here, the person appointed may or may not be a shareholder of a particular company. So under section 143, a person holding a proxy can vote on a poll. So this person who is being appointed as a proxy uh, has the same rights as the person who has appointed him or her. So a person holding a proxy can vote on a poll unless the articles of association disallow it. So here the proxy can be also the proxy can also be revoked before it has been acted upon by the company or by the member attending or voting in person. So here I'm looking at how a proxy can be revoked. So it can be revoked uh, by the member attending, the person who had appointed him, by that person attending. It can also be revoked by that person voting in person. So the company notice, I mean the notice of the meeting must specify that the member is free to appoint a proxy for that person to give rights to another person to come and represent him in a particular meeting. So that is that with proxy. Moving to the officers and members of the company. Before I hint on the officers and members of the company, if at all I'm to look at something very small to do with the company meetings, I can also look at the minutes, company minutes, whereby every company must have the minutes of all proceedings of its general meetings and also meetings of the directors. So such meetings, once signed by the chairperson of the meetings, shall be the evidence of the proceedings of the meeting. So here the meeting shall be taken to have duly to have been duly held and conveyed, that is after the chairperson signing those minutes. So failure to take these minutes creates liability for every officer in default of a fine of 25 currency points, which equate to 20,000 Uganda shillings. So that is that with the company meetings. Then that's when I can look at the board of directors.
Thank you so much for watching. Make sure you subscribe to the channel.